Morning, colleagues, and indeed anyone observing this meeting. I'm delighted to say this is the first public meeting of the SPA Legal Committee held on the 13th of March. Just by way of a short introduction, as committee members and other attendees are fully aware, and as has been reported regularly to the board, one of the key objectives for the Legal Committee over the past few months has been a drive to ensure that we increase the transparency and visibility of the committee and its work. By doing so, we'll be increasing the overall public accountability and transparency of the authority and its oversight role, which in turn supports public trust and confidence in Police Scotland. I'm therefore particularly pleased to be introducing this, our first public session of the committee, operating in accordance with our corporate governance requirements and our standing orders. We will in future be conducting at least part of the regular meetings in public. As chair, I'll be adopting a policy of principled pragmatism, so operating within clear expectations of transparency, but also appropriate confidentiality. And the pragmatism recognises that we're looking for continuous improvement, not immediate revolution. So in public, we'll have a focus on seeking overall systems assurance. That will include being better sighted of underlying data and analysis, and allows identification of different aspects such as emerging trends. In this sense, the committee is on much the same journey as the Complaints and Conduct Committee, as seen in their meetings and in their recently published annual report. But because of the nature of the committee's remit, which includes consideration and decisions on individual cases, we will always expect a significant amount to be conducted in private. But while that will always be appropriate, we'll also give consideration to other options. Examples might include publication of a paper with appropriate redactions following a meeting, and/or more detail given by way of committee chair's report to board meetings, as was the case last month, where we provided information on the committee's consideration of Operation Tarn, the Shaker Bayou inquiry. With this by way of introduction and explanation, and indeed welcome, can I move on to the formal agenda? And so in terms of the formal agenda, apologies. Do we have any apologies from committee members? I think we may have an apology from Katrina Stewart. Is that correct? Colette?
No, she's currently trying to log in. She's just having IT issues at the moment. I'm hoping she'll join shortly.
Right, and the same I think is true of Grant McRae, but we are quorate as we start.
That's great.
Declarations of interest and connections from the committee members present. Michelle, no. Michelle Miller has kindly agreed to stand by in the hopefully unlikely contingency that the IT fails and I fall off. Michelle can stand in as chair. And so we now have item 1.4, decision on taking business in private. And that's a very appropriate moment to remind ourselves about the standing orders, and as I say, that distinction between what is always going to be appropriate to hear in private, but we should be considering each of the items. So in this case, and slightly unusually, we have item 7, the minute from the meeting held on the 13th of December, because that was in private. That I think falls within 20 little I of the exceptions in our standing orders, but in future we would expect the meeting of the public session to be then heard in public, and the meeting of the private to be heard in private. Are members content with that? Yep, thank you very much. Pretty much, I think each and every of the next 8, 9, 10, 11, 12, 13, 14, 15, all fall within the provision of 20D, which is matters that are the subject of legal proceedings. And I think that is stated at the heading of most of the papers. Are members content with that? Yeah, we record that. Thank you. And finally, the committee statement of assurance, item 16, is a slightly unusual one. It happens once a year. It's exceptional circumstances which would justify considering the matter in private, and indeed, I think H, free and frank provision, but it's the statement of assurance which the committee then gives is heard by ARAC and is ultimately incorporated in the annual report and accounts. So there's something of a time lag, but it is disclosable in public eventually. The members content with that?
Yes.
Thank you very much indeed.
Chair, apologies for my late arrival. I was logged on earlier on without any problems, but at 5 to 11 it wasn't working.
Has a mind of its own. Absolutely sure. Good. So we will move on then to consideration of business in public. And agenda item 2, statistical report on the whole health, retirement and injury. And this is something which has been within remit of the committee. Maybe we come to this later, as something might move across to another committee, but in the meantime, Jackie Kidd. And it might be worth saying, because this is the first meeting in public, you might want to offer just a sentence or two on explanation of why the background to this and why it comes to the committee, even though we have read the report. Thank you, Jackie.
Thank you, Chair. Good morning, committee. Yes, just as a brief introduction to this report. So this is a report of decisions that are taken under the delegated authority of this committee by the Chief Executive on matters of ill health, retirement and injury and duty. The numbers that have been approved since the last meeting of the committee are set out in the tables in the report. And as you kind of highlighted, this is also a topic that is discussed in the People Committee around the improvements and things that were taken forward within that space. But at the moment, this is under the delegated authority of this committee, so therefore that's the reason for the reporting back into the committee. The numbers are increasing, as you will see from the report, and as that is the projection going forward, that will be the kind of level of numbers that will be being approved month on month. So happy to take any questions members have on the report.
Any questions or comments from members? No, I think it might be worth observing that actually this is one of those cases where an increase in numbers at this point is a positive, because as has been reported from the committee previously, there was something of a delay. Would that be correct?
Yes, that's exactly it. So these are back to probably what we would expect to see on the kind of monthly numbers coming through. So yes, that delay has now unblocked to an extent, and these are now the levels we would hope to see going forward.
Good, that's very positive. Thank you. Thank you very much, Jackie. Okay, Caroline.
Yeah, it was really just, my question was very similar to yours, Chair, and it was just to say I think that's been a massive improvement. So
Yes.
I just wanted to congratulate the team, because I know that's been a lot of hard work. So I just want to say well done, because that's been great getting on top of that. So thank you.
Thanks, Caroline, and I will pass that in, because the majority of the work to unblock this has been done in Police Scotland, so I will make sure the committee's thanks are passed on to the team in Police Scotland that have worked really hard to move this along.
Yeah, great job. Thank you.
Okay. Thank you. Okay, so let us move on to agenda item 3, Police Scotland legal data, and that's certainly been something of great interest. As I say, the committee has been focused on increasing accountability and visibility, but the second of the main objectives and topics for the committee has been the importance of data. What do we hold? How are we using it? What can we learn? James Douglas, the Legal Services Manager, you have kindly pulled together a briefing for us. We having asked, could we have this? You've gone and said, this is what you have, and this is the improvements I think you're suggesting in the spirit of continuous improvement that could be made. James, speak to this.
Yes, thank you, Chair. At the danger of actually just parroting what you said, the report sets out for committee members the information that we currently have within our claims register. And just for the benefit of members and anybody watching these proceedings, the claims register is a document that narrates all of the claims that Police Scotland face. And it's primarily a tool used by the solicitors and finance colleagues so that reserve positions and the litigation landscape can be monitored and recorded. However, it is it's a system that was created by us in legal with the help of finance colleagues almost at the inception of Police Scotland. And it'd be fair to say that it does the job for which it was created, but what it doesn't do is provide some of the more statistical analysis that the committee are seeking going forward. So with that in mind, I met with finance colleagues on a number of occasions, and indeed one of the solicitors within the department has been working on this on an ongoing basis with my finance colleague Alia Hamid. And what they have come up with is a series of drop-down menus within the claims register that will allow us to differentiate between cases within the three main sections of public liability, employer's liability, and motor liability. At the development day, members said that public liability covers a myriad of things, and what we wanted to do was maybe break that down slightly. And this is all in furtherance of organisational learning. So that the paper narrates that we intend to create a number of drop-down categories within each of the three main criteria. And I won't go through them all, but what I would say is that the options contained within there represent the cases that we more often than not deal with, and there always will be an option of other, because we can have cases that we've never dealt with before. But most of them for public liability will be about tripping or wrongful detention or an injury to a person, the loss of property, that type of thing. So it will allow us in future to come back to you to say, within the realms of public liability, here's what most of these cases deal with. Within the employer liability, we've taken the view that it could almost be split into two main categories: employer liability for injuries at work, and then employment tribunals on the other side, so that members can see, for example, if there has been an increase in age discrimination cases or disability discrimination cases, we can very quickly see that there's been an increase or a decrease in those types of cases, and then motor liability will inevitably remain as it is, as they all involve crashes, bumps, and scrapes. These proposed changes are very embryonic. As I say, it was following the development day that I've met with finance colleagues to see what we can put in place. What we are hoping to do is be able to provide you with the geographical information that you sought as well going forward. But I have to say that these will not be implemented immediately, as we are at the year end, and these matters are still to go through SNT and finance to ensure that the claims register still does what it was brought into existence to do. So I hope you can see that we have taken on what you're requesting. We're trying our best to give you that information going forward, but it's not something that I'll be able to snap my fingers and get it for you anytime soon. But happy to answer any questions.
Okay, thank you very much. I wonder, I don't want to preempt the debate, but just for the avoidance of doubt, that this is not a new case management system or indeed document management system where there are some recommendations via internal audit. There's been a lot of discussion, but we recognise that the introduction of new systems like that, because as you say, this is a development of something which has been in place, as indeed you note in the paper, for 10 years. It's resource dependent, and the question would be whether a new system was a priority at a time when we recognise the extreme financial pressures elsewhere. But I just think it's perhaps worth clarifying that. Is that a correct summation of the position?
That's spot on, Chair. This is work being done to the existing system at the moment. It is not a case management system. We absolutely take on board the recommendations within the audit report, and obviously that has been a matter of discussion at this committee on a couple of occasions now. But we hope that these amendments will at least bring some statistical information that you may find useful going forward. But you're correct, it is not a case management system.
Yeah. Thank you very much. Caroline, you have your hand up, and I don't think that's a legacy hand. But you are on mute.
Actually, it was a legacy hand. But I've read this, and James, I know that in the absence of a new system, this is kind of a lot of retrofitting work. So I just want to say I appreciate that, and I think you've taken the discussions that we've had on board, and it looks, from the looks of it, that we'll get a lot more kind of granular information going forward. But I appreciate that that's a lot of retrofitting when you don't have a new system to do it in. So thanks for that.
I think another of the questions we may look at later, you recognise that this includes tribunals, it includes therefore court actions. We might have a discussion, I think, as to what we mean by settled. That is, whether does this include, or how do we get to the extent of awards by the court, which my understanding is there are actually very, very few that are court awards as opposed to settlements. But James?
Yes, the overwhelming majority of settlements reached are made by simply looking at the evidence prior to any case calling. As we all know, matters simply proceeding to proof where there's little prospect of success simply involves us paying out more in expenses. So an awful lot of the time we take the view that, yes, we did bash into a fence with a police car, and nobody else did that. We did it. We didn't put the handbrake on. Therefore, we'll settle the cost of the fence. The settlements on the claims register, just for clarity, are any amounts of money that we pay out with regards to any matter that's been raised against us. And we brought those statistical reports to this committee so that there is absolute transparency to you in your role as oversight and governance. No payment is hidden from you within those statistical reports. It is every single penny that you pay out.
Thank you. Any other thoughts, Grant?
Yeah, thanks, Chair. James, it's very helpful summary of the different bits of information that you're gathering, and that's helpful. The one area that I just wanted to explore, and it's more for clarification than anything else, is how this ties into the journey of a case, the progress of one. Is that being dealt with in this register under some section, or is it linking in with some other record so that we can actually see how each case is progressing?
The claims register will continue to have a free entry box for how the case is proceeding. But as I explained within the body of the paper, free text entry makes it extremely difficult to provide any kind of analysis, simply because there's no control as to what's entered into that free text area. But you may take it that each and every month legal services meet with finance, who have access to the claims register at all times, but they certainly have it at an up-to-date position, and they can see the progress of cases. We have had a discussion around this previously, where it was pointed out that despite what the auditors suggested, that a handle has to be kept on how quickly, or as they were pointing out, the slowness of any case is dictated by the facts of that case themselves. It's not dictated by the amount of money that's being sued for or anything like that. It's about evidence, ability to have expert witnesses available, and a myriad of other things. But finance colleagues and the solicitors themselves will continue to see information about the rate at which cases are being settled. But as I said, without case management and whatnot, it's a very difficult thing for me to bring to this particular committee. But you may take some comfort from the fact that it is under constant governance and oversight from finance colleagues. And you will clearly always be given the litigation tables, which is part of the agenda, the standing agenda to this committee.
Yeah, thank you for clarifying. So from this committee's perspective, our oversight of the progress, or perhaps frustration at the maybe slow progress in some cases, we will pick that up purely from the litigation tables. Is that, am I getting this right?
I think you've got that correct, yes.
Right, okay, thank you. Thank you for clarifying. Thank you.
Thank you.
Thanks, Chair.
So I think the next iteration, the next step is we know what use is being made of the data and the extent to which you are able to bring even if not scientific, perhaps some narrative conclusions would be interesting in terms of trends in data, but this is something that will evolve, I think. Michelle, did you have any questions to ask? I think. No, okay. Well, I think for the purposes of the committee, James, I mean, we welcome the proposals that you're making here. And although you say they've not been agreed by legal services, SMT or finance colleagues, I hope that they will agree them, because I think they are, you know, pretty fundamental to the work of this committee and to demonstrating the oversight of this committee and the appropriate management within Police Scotland. So the action we would seek from this committee is that those changes that you propose should be introduced, and we would welcome those, and sight of the analysis and the conclusions that enables you to draw and bring to this committee for further inquiry. Would that be a fair summary? I'm not sure that we can put an absolute deadline on that, but nevertheless, since that's an action, it will be an action that will be appearing in the action log, and we will be asking for a continual update on that. I would be extremely disappointed if we were at this point next year, was the end of the reporting year 23/4, and we had not made progress on that. James, is that realistic from your point of view?
I certainly think it is. I mean, as I say, within the body of the report, Chair, this is a bit of work that has been undertaken with our finance business partner, and have allocated a solicitor to it, and I've taken oversight of it myself. So I would be hopeful that we could implement this, but I felt I had to advise the committee it's still very embryonic. We're still coming up with ideas at the time of writing the report, and it still has to go through the SMT and finance, but I would be hopeful that they would be incorporated.
Well, I think then I will pluck a figure out of the air and say I would very much like to see it introduced by September, and let's put that as an intended deadline for introduction. We'll see where we go with that. Okay. Thank you very much. That's certainly some progress. Item 4 then, non-disclosure agreements. Now this has been something this committee has been tracking for some time, and we have a report here as to which really sets out the progress that has been made. James, you can speak to this and as to, I think, why this might be the last in its final form.
Thank you, Chair. You're absolutely correct. Non-disclosure agreements have featured in this committee now since December of 2021. And the committee undertook oversight and governance of the use of NDAs throughout the calendar year of 2022. Members may recall that I brought numbers of NDAs that were entered into within the previous quarter, together with a running total of those that were entered into in the calendar year. And each report was married to an appendix where I gave reasons as to why NDAs were entered into in particular cases. I would respectfully submit to the committee that having had these reports over the calendar year of 2022, I would hope that the committee have been satisfied that NDAs are not entered into without good reasons, that they're not entered into in any way, shape or form to prevent whistleblowing or anything else protected by law, and that often NDAs are requested by the other party to the agreement where they wish to keep information about any settlement that they've received confidential, and quite clearly Police Scotland would not be minded to refuse to enter into an NDA in those particular circumstances. So, as I say, I would respectfully submit that the SPA Legal Committee have exercised their oversight and governance of this matter. I would respectfully submit that they have been provided with comfort that they are being used for good reason. And I've stated within the body of the report additional measures that have been put into place as a result of NDAs starting to feature to the tail end of 2021. The main ones being that our external agents, who perhaps in the past would have entered into an NDA simply because it is a standard clause within a settlement agreement, have been instructed not to do that, and that permission has to be sought from the instructing solicitor within Police Scotland before an NDA is entered into. If an NDA is entered into, a sheet has to be completed and put into an NDA register, which is now kept within my office. So they will have to explain their thinking behind it. So I'm the first guardrail against any abuse of an NDA. However, more importantly, DCC Taylor has instructed that a report go to her closed board detailing NDAs. She's very much alive to the fact that they do attract scepticism and suspicion, although she's also aware that they are a legitimate tool used daily in the settlement of cases. So it's, as I say, it's my respectful submission that oversight and governance has taken place by this committee, and I would submit that the committee should have got some comfort that they are not being widely used and certainly never abused. Happy to answer any questions.
Thank you very much. Michelle.
Thank you, Chair. Thanks for the report. I really welcome, the increased emphasis on transparency that I think this represents, and I am kind of reassured by the lines of defence as you describe them. So that's all really good. I suppose there's a couple of things I'm interested in. One is the extent to which those lines of defence you're intending to strengthen them in terms of reducing further, and whether and where there's any scope for doing that, because I do think it's almost irrespective of the individual nature of the claim, there's a much wider issue here, which is about transparency, and I think that's really important. So that's the one question. And the other question is in relation to those cases where it's the other party who's requesting it, and whether there's just an automatic assumption that if it's requested, that non-disclosure agreement will be entered into, or if actually what we're also saying is that in relation to those cases, there is some level of consideration, analysis, assessment about whether we would agree to that, or whether there's just an automatic, if it's requested by the other party, that's what would happen. Because I think if that, and I don't have a view either way because I haven't really thought it through, but it would be interesting to know whether that is just the absolute position, or whether there is some capacity to move that agenda on as well, and just understand some of the considerations around that.
Yes. If you can take your first point first, which is, are there any mechanisms in place to perhaps decrease the numbers that we are using? I think I brought to this committee a report at the start of 2022, which shows that we enter into NDAs in about 2% of all cases that we settle. And those are often for commercial reasons or confidentiality agreements on behalf of the other party. So what I would say is that the amount of NDAs that we enter into already starts at a very, very low level, and I really do not have too much power in the way of reducing those further if we take it that the ones that we do enter into are done for good legal reasons. I would say that we will continue to use them if there are sound reasons for doing so, but they have reduced in number simply because external agents have now been told, do not use these as a standard clause. You may do that for other clients, don't do it for us. It has to be okayed by the solicitor. So what I would say is that there has been a decrease in their use. However, reducing it further going forward, I wouldn't wish to say to the committee that would necessarily follow, simply because we do enter into them so rarely. In respect of the second one, it's a very good point that you raise. Very often a decision is taken by the other side that they wish confidentiality around the amount of money that they perhaps received. And if I can be so candid, sometimes it's to mask that they didn't get anything like what they perhaps were looking for. And I think we would always take the view that should the other side wish to enter into an NDA to keep confidential any settlement figure, we would be loath to lose the position of settlement simply because we would not enter into an NDA. What I can say to you, though, is that where the other side have asked to enter into an NDA, we are now recording that as such, because it was a great source of frustration to me when I was coming to this committee at the tail end of 2021, where I would say we entered into 9 NDAs, but you're looking at it and 5 times it was the other side that wanted to enter into it. We are now recording that, and they will be recorded separately. It's not an automatic decision. There still has to be good legal reasons for entering into any settlement and the clauses contained within that settlement. But what I would say to you is that where the other side are adamant that they would like an NDA entered into, Police Scotland would be minded very much to do so if it brought the matter to an end, because the alternative is that we may have to proceed to a proof for a tribunal.
Thanks, that's really helpful, James.
Thank you.
Yes, thank you. I think that point about who requested it is a very helpful point. Thank you. Grant.
Thanks, Chair, and thanks, James, for your report. And also, one of the questions I had has already been dealt with from Michelle's questioning. What I just wondered about was, I fully accept the enhanced form of governance and recording, but I wonder at what point will this committee learn, even in summary terms, what further NDAs have actually been settled, whether at the request of the other party or from ourselves. I think somehow or other there has to be some way of us seeing from time to time what the impact of these changes has been.
I would be happy to bring, for example, an annual report on the use of them, together with the reasons. I think to date, the committee has asked, or throughout the calendar year of 2022, we've asked that information be brought around all and every NDA, the reasons behind it and whatnot. And what I'm respectfully suggesting is that oversight and governance has now come to its logical conclusion. But should the committee still wish sight of the numbers being entered into, I could bring an annual report detailing the numbers.
Yeah.
I think that would be very helpful. Thank you.
And I think that's a good example of evolution, and that's a good example of perhaps that could be mainstreamed within an annual report, and a number of other aspects. Probably there are one or two areas where we can move from the quarterly to the annual with a discussion not simply of the raw data, but what that has told us. It's also worth pointing out, for the avoidance of doubt, and perhaps partly because this is the first public meeting, that in our disclosure log, that was one of the things that had been requested under FOI. So there is the paper of September 2022, which dealt with non-disclosure agreements, a statistical update, suitably redacted. So this is something that has been, where the committee has been exercising oversight, where there's been a degree of information in public, and I think that's, but I think dealing with it by way of an annual report now seems appropriate. So as an action, would the committee be content to say that there's no longer a requirement to bring this on a quarterly basis, but an annual report, unless obviously you can always report on an exception basis if you got a sudden spike of them, but in the ordinary course of business. Content? Yep. Okay, thank you very much, James. Good progress. Okay. Agenda item 5, review of SPA litigation and claims procedure. Susan Montgomery, our internal SPA solicitor. Speak to this.
Chair. Yeah, yes, I can. This is the review of the SPA litigation and claims procedure, which the Legal Committee approved in December 2021. The SPA legal team have now carried out a review of that, and the procedures are working well. So the revisions that we've suggested are very minor. There were links in the document linking to other legal spreadsheets and databases which no longer worked, so we've removed those. We have inserted reference to the Section 83 agreement in the paragraph that details services back from Police Scotland Legal Services, but beyond that there's not much to add in way of revision to the procedures. So my request today is that the Legal Committee approve those revised procedures which are appended to the report.
Committee content. I'm particularly pleased to see the impact of Section 83 making its way through. Well done. Yep, content. Good. Thank you very much indeed. Thank you. Approved. And the final item is the Legal Committee work plan, which is always a sort of work in progress. And I think we will do a bit of updating. Indeed, we've just had something, I think, on whether quarterly reports or annual reports, and we can look at that in due course. But I think there are certain items which are routine, and then the focus for the committee over the coming month, I think, is definitely sitting in the area of systems assurance, real systems assurance, not just the individual cases, and the work which is ongoing, which, as I say, was reported at the board, but the good work which is ongoing in respect of Police Scotland's internal handling in respect of the Shaker Bayou inquiry, and the lessons which are being learnt from that, and which will undoubtedly flow through to other tribunals and inquiries. And that is something that we are going to look at again in more detail in the private session, but that may be something that is a little bit more information is reported publicly via the chair's report to the board. And indeed, that might be a verbal report because we've got a board meeting next week. Okay. Grant.
Thanks, Chair. Just in terms of the table for the further meetings, I see legal costs as being shown as being recorded today, but not apparently being planned for subsequent meetings. And I think we would benefit from having this on a more regular basis. Maybe not necessarily every meeting, but certainly in various intervals during the year.
Yeah, an adjustment between what comes to individual committees and what comes annually, and maybe that's the quid pro quo for the NDAs. Yeah. Okay. Anything else that should be heard in public? If not, I will bring this very short, but I think significant first public session of the committee to an end. Thank you for everybody attending. I hope we had people watching us remotely, both in real time and possibly subsequently. So thank you very much. So we close down the live stream.